This video is going to be talking about the administration of justice. I'm releasing it in order to help individuals who are seeking to obtain the enforcement of their own fundamental rights and freedoms here in Canada. It's not meant as legal advice. It's just meant to help human beings enforce their fundamental rights and freedoms. Now, we have come to learn over our studies that the administration of justice means to uphold fundamental rights and freedoms, charter rights, common law rights, better known as natural rights. If you don't know what I'm talking about, then I think you should watch some of my prior videos before continue on watching this video. Now, common law in Canada now develops in accordance with the Charter of Rights and Freedoms, better known as the Constitution Act of 1982. When you look into Supreme Court, it has made it clear in cases M.A. versus Ryan that common law must develop in accordance with charter values, that the common law trespass equals an infringement or denial of a fundamental right or freedom. Here we find the Supreme Court declaring that common law must develop in accordance with the Charter. First, we must note that it is the Superior Court or Supreme Court making this declaration. So, if we go into Superior Court, we must prove a common law denial by proving a charter infringement. We are also seeking the administration of justice, as we have seen declared in the following judgment. In Gerald Mitchell, this is from the Supreme Court of Canada, he states that the administration of justice, and I go down, according to Grant, it means the term administration of justice in Section 24 of the Charter concerns maintaining the rule of law and its process and includes upholding charter rights in the justice system as a whole. So when you use the term, I'm seeking the administration of justice, what you are saying is you are seeking to uphold your charter rights within the justice system. You are seeking to uphold your common law rights within the judiciary. As we know, common law does indeed exist in Canada. When you look into the Interpretation Act of Canada under Article 8, you find that it states that property and civil rights exist in Canada either common law wise or civilly wise. So they mentioned that two of them exist. Then when you go into the Quebec Civil Code, the preamble, before you read the code itself, it specifically says that the Quebec Civil Code is an expression of jus commun, which means common law, whether directly mentioned in the code itself or implicitly mentioned, which means it's hidden in there. So if you understand what common law was, and you were reading the Quebec Civil Code, you'd be able to pull out the articles of law that dealt with common law. Now, many people understand, who are looking for their rights and freedoms, that there is such a thing as common law in Canada. But the question comes, where is it, and how do we defend them? How do we defend our common law rights? Now, when we look to the Supreme Court of Canada, that's a judgment from the Supreme Court of Canada and M.A. versus Ryan, it teaches us that common law in 2015, actually this would be from 1982, that this would be going back, because that's when the Charter came into existence in Canada. But the Supreme Court of Canada is teaching us that common law must develop in accordance with the Charter. So it's not a fact that there is not common law in Canada, there is common law, and however now it is expressed through the Charter. So our common law rights that have been in existence for many generations are now expressed through the Charter, and actually goes deeper. It says that a trespass in common law now will be an infringement of our fundamental right or freedom. So common law rights are now enforced or now flow through charter rights. And these rights in Canada can be infringed or denied. The executive powers, they can create enactments or regulations that infringe or deny your common law rights, your charter rights. Now, Gerald Mitchell of the Supreme Court of Canada did an exposition upon this, and he wrote that anyone who is seeking to enforce their charter rights are actually seeking the administration of justice. Because common law rights are first and foremost. If you understand common law, fundamental rights and freedoms, natural law, fundamental law, these are all first and primary rights that man can express, that a woman can express. Now, second to this are enactments and regulations. So when we come to seeking the enforcement of our fundamental rights and freedoms, it is termed the administration of justice. That's what we are looking for. We are saying that an enactment or a regulation has gone against our fundamental rights and freedoms, therefore we are seeking the administration of justice. We, as individuals, are seeking to have our fundamental rights and freedoms here in Canada respected. We have come to realize that the executive powers are denying them and infringing upon them, and we are seeking the administration of justice. Many of us have contacted and will probably contact the Office of the Attorney General of Canada concerning our fundamental rights and freedoms. This office has a superintendence over the administration of justice. The office is charged with the duty to uphold and attend to all matters as it pertains to the administration of justice. Now, when you look in the Federal Department of Justice Act, you find the following in Article 4. The Minister, meaning the Attorney General, is the official legal advisor of the Governor General and the legal member of the Queen's Privy Council for Canada, and shall see that the administration of public affairs is in accordance with law. That deals with the democratic society. And then secondarily, he shall have the superintendence of all matters connected with the administration of justice in Canada, not within the jurisdiction of the governments of the province. So the Federal Attorney General of Canada has the power, has superintending power over all matters. You see that? All matters connected specifically with the administration of justice. However, these matters must not be under the provincial jurisdiction. The Minister, who is also the Attorney General, is responsible for superintendence of all matters connected with the administration of justice. These matters must not be under the provincial government's responsibility. So, the administration of justice is flowing from the Minister of Justice. He has superintending powers over all matters that are not under the control of the provincial government. This verse is declaring that when an individual is seeking the administration of justice, that there are times that the justice will be obtained through the provincial means or provincial courts. Then there are other times when the office of the Federal Attorney General is the means to obtain justice. When we look into the statute and regulations from the federal enactments called the Department of Justice, or when we look into the provincial one called the Department of Justice enactment, we find federally that there is a title or a designation called the Federal Attorney General. And in the provincial, there's someone called the Provincial Attorney General. Now you saw that both of these offices have been charged with the administration of justice. So they're both responsible for upholding charter rights, our fundamental rights and freedoms within Canada. Now, it specifically says that the Federal Attorney General deals with the administration of justice that is not under the control of the Provincial Attorney General. And then it specifically states that the Provincial Attorney General deals with the administration of justice that is not under the control of the Federal Attorney General. So both of these offices have their duties and their responsibilities to uphold our fundamental rights and freedoms for the administration of justice, but you have to be careful because, again, there's a distinction. The Federal Attorney General deals with matters that are not under the care of the Provincial Attorney, and the Provincial Attorney General deals with the administration of justice that's not under the care of the Federal Attorney General. So if you have a problem and you contact the wrong Attorney General, you won't get the response that you're looking for. For example, if you have a problem and the administration of justice lies within the Provincial Attorney General, but yet you contact the Federal Attorney General, you're not going to receive the response you're looking for. And vice versa. if the administration of justice lies within the federal attorney general, it was a federal enactment, but yet you contacted the provincial, you won't get the response you're looking for. So we have two offices that are charged with the duties concerning the administration of justice. We have the federal attorney general and we have the provincial attorney general. Now, for any individual who's seeking to exercise their fundamental rights and freedoms, they have to discern and figure out what is under the federal attorney general's control and what is under the provincial attorney general's control. You'd have to go into the Constitution Act of Canada, 1867, in Article 91. There, you will find the matters, the subject matters, concerning what the federal attorney general is under control, what he has control of. Constitution Act 1867, Article 91. When you look there, you will see a list of all the matters that the federal attorney general has control of. Same thing. You'd have to go to the Constitution Act of 1867, Article 92, to check what the provincial attorney general has control of. Because there you will see the provincial powers have been delegated to the provincial legislators, and they will be creating provincial enactments. And if these provincial enactments breach your rights, your fundamental rights and freedoms, then you have to go after the provincial attorney general. But if you look and it's a federal enactment that is breaching your fundamental rights and freedoms, then you have to go after the federal attorney general. So it's very important that you discern the situation. Who has control of the situation? What enactment is stripping me, is removing my fundamental right and freedom? Is it a federal enactment or is it a provincial enactment? Then I will know where to target my attack for the administration of justice. Now, each subsequent province has a Department of Justice enactment, and we look into the duties of the minister. The minister is the official legal advisor of the lieutenant governor and the legal member of the executive council. Now, the attorney general here, it's mentioned that he's the legal advisor of the lieutenant governor, and the lieutenant governor is a representative of the Queen. Now, also, the attorney general is a legal member of the executive council. You see that? The executive council is part of the ones that are here in control of Canada, that are governing Canada, but yet he's also in charge of the administration of justice. Talk about being put in a weird situation. Now, the provincial attorney general shall see that the administration of public affairs is in accordance with the law, and shall superintend all matters connected with the administration of justice in the province that are not within the jurisdiction of the government of Canada. So again, we see the distinction. The federal attorney general of Canada has powers to deal with the administration of justice if the problem is not under provincial jurisdiction, and the provincial attorney general has powers to deal with the administration of justice if the matter is not under the control of the government of Canada, meaning the federal attorney general. Now, the governors appoint the attorney general of Canada, and I used Manitoba here for an example, and attorney general of Manitoba, and they are charged with the administration of justice, the attorney general of Canada, and also the attorney general of Manitoba is charged with the administration of justice. Now, we're not talking about the individual men who are sitting in these offices, because those roles change term by term or whenever it is. However, what we're talking about is the office itself. An office is controlled by an enactment or a regulation. The duties and responsibilities that an office has is brought forth through an enactment and a regulation. And we just saw through both enactments, in the Department of Justice enactment, that both of these attorney generals have been charged to superintend over all matters concerning the administration of justice, concerning upholding charter rights and fundamental freedoms. We know that Her Majesty has the obligation to respect and ensure our fundamental rights and freedoms, as found in international and domestic law. We see that this obligation is imposed upon the offices of the Attorney Generals by charging these offices with the responsibility of the administration of justice. Administration of justice means upholding fundamental rights and freedoms, charter rights. The Minister of Justice has been charged with this responsibility. The provincial government has this responsibility also. Looking back into the enactment, we see the following duties and responsibilities coming out upon the office of the Federal Attorney General, the Minister of Justice. Now, Department of Justice Act, Minister and Attorney General. The Minister is ex officio Her Majesty's Attorney General of Canada, holds office during pleasure, and has the management and direction of the department. The Minister is the official legal advisor of the Governor General and the legal member of the Queen's Privy Council for Canada. So you see, the Attorney General is Her Majesty's attorney. He's also the legal advisor to the Governor General, and he's the legal advisor to the Queen's Privy Council. This office is playing multiple roles. While these duties, if handled with honor and care, complement one another and allow the individual playing the role to accomplish the administration of justice, this office can also be used to hinder the expression of justice. This office is under obligation to ensure and protect fundamental rights and freedoms, yet this office is also the legal advisor of the Queen and the Crown. Further to this, this office of the Attorney General has regulation and conduct in all litigation against the Crown or any department of the Crown. So, the power to do right or wrong is present within the duties and responsibilities, the powers that this office exercises. Okay, so within your local province, it doesn't matter what province you are in, you have your provincial Attorney General. Now, we want to look at the court structure that's operating within the provinces to see what's transpiring. You have statutory courts. So what is a statutory court? A lot of people ask that question. A statutory court is set up by enactments and regulations. That's where it has its power. It can only follow the rules and law of the enactments and regulations. Now, for example, a traffic court. Traffic court would be considered a statutory court. I go in there and it can only deal with one matter, my ticket. That's it. Of course, on the other hand, it should fit in the administration of justice, but that's not what we're talking about. We're talking about the fact that it's just a statutory court. So, for example, I'm under private contract with somebody, and I have a disagreement with them concerning that contract. I wouldn't tell them, okay, listen, fix up this problem right now, or I'm going to take you to traffic court, because I have a civil disagreement with you. It wouldn't work. I couldn't go to traffic court and say, hey, judge, this guy promised to do a whole bunch of work for me. I paid him half in advance, and he never did the work for me. He took my money and he left. The guy would say, oh, well, I can't hear your case. This has nothing to do with tickets. So a statutory court can only deal with a certain matter. For example, again, traffic. Now, also in our provinces, we have something that's called the Superior Court of the province. Now, this is a court that can deal with the inherent jurisdiction, that can deal with the administration of justice straight up and front. It has the power to deal with our fundamental rights and freedoms. Now, getting back to the statutory court, and I'm going to get into the Superior Court a bit more, but getting back to the statutory court, when you study the Supreme Court of Canada, and you see concerning the administration of justice, it specifically teaches us that a statutory court, if we go in there before them, seeking to exercise our rights, or seeking the administration of justice, they're supposed to fit in to the existing scheme that is going on, our administration of justice. So you walk in there and you say, listen, I believe this enactment has stripped me of my fundamental right and freedom. I don't think it's of any force or effect against me, according to the Constitution Act of Canada, Article 52, and here's the reason why. Now, when the judge hears you out, he's supposed to be able to say, yeah, you know what, that's of no force or effect against you. I'm not invalidating the legislation. Get on out of here. I'm dismissing the ticket. He has the power to do that, a statutory court. Do they do it? Sometimes, sometimes not. I see a lot of times when they do it, and I see other times when they don't do it, when the judge is being hard up, where, oh yeah, it's my court, and I'm not going to administrate justice here. What he's actually saying is that if I screw you here, that you're going to have to go here. And most people don't understand how to go here and don't know the powers of this court. But a statutory court should be fitting in the administration of justice when it comes to our claiming there's been an infringement or denial of our fundamental rights and freedoms. But above that, the superior court has all power. In your province, if you have a problem with your province enactment because it stripped you of a fundamental right and freedom, the provincial attorney general has the power to deal with the administration of justice. And when we look into the court system, we're going to find that this is a very powerful court to operate on my behalf and your behalf. The Attorney General of Canada, Article 5, is charged with the settlement and approval of all instruments issued under the Great Seal, and shall have the regulation and conduct of all litigation for or against the Crown, or any department, in respect of any subject within the authority or jurisdiction of Canada. The Attorney General is to address the situation if your fundamental rights and freedoms have been infringed, yet the office is also Her Majesty's legal counsel and the Crown's counsel. The office has the power to regulate this problem concerning the administration of justice, but the office also has the power to try and protect the Queen and the Crown's interest in this matter. Attorney General is ex officio to the Queen, is a legal advisor of the Governor General, and is the legal advisor of the Privy Council. The Attorney General has been charged with all matters connected with the administration of justice, regulation and control of claims against the Crown. Now again, the powers, duties, and functions of the Minister. The Minister is the official legal advisor of the Governor General and the legal member of the Queen's Privy Council for Canada, and shall have the superintendence of all matters connected within the administration of justice in Canada, not within the jurisdiction of the governments of the provinces. The Federal Attorney General deals with the administration of justice that is not within the jurisdiction of the provincial governments. When individuals searches out their rights and freedoms, they will find that there are certain fundamental rights and freedoms that have been charged into the provincial government, the provincial attorney general, and others that remain the federal government, attorney general's responsibility. Common law has existed for many, many generations, and while now it must develop in accordance with the Charter of Rights and Freedoms and the International Bill on Human Rights, the administration of justice has always been present, even though it may not have been very enforceable. When we looked at that judgment, R versus Haynes, it states, prior to the Charter's advent, the individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative arm of the state. Law and the Constitution hinges the existence of public order, and it mandated compliance with directives and ordinances, even if they infringed upon individual fundamental rights and freedoms. Now, a primary purpose of the Charter was to change this relationship with the individual and the state and its laws by endowing individuals with an effective means of challenging the acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. So when you're looking for the administration of justice, it breaks down as follows. The Federal Attorney General, he has the power to superintend concerning the administration of justice, to uphold your fundamental rights and freedoms. This flows into the Federal Court of Canada. And concerning the administration of justice, the Provincial Attorney General, this flows into the superior courts and into all other courts. Now remember that in the Supreme Court of Canada, Gerald Mitchell mentioned this. The Charter itself contains no procedural directions. The absence of jurisdictional provisions and directions in the Charter confirms the view that the Charter was not intended to turn the Canadian legal system upside down. What is required is that it be fitted into the existing scheme of the Canadian legal procedures. There is no need for special procedures and rules to give it full and adequate effect. So, when we're talking about the administration of justice, if I seek this, if I'm the one that goes in and says, listen, the way you're treating me through your enactment and regulation is stripping me of my fundamental rights and freedoms, then if I go against the federal court and I go against the Attorney General, that's the federal way. If I go against the provincial, It's the provincial superior court and the provincial attorney general. However, if I'm brought into court, example for a traffic ticket or any other reason, any court is supposed to hear the administration of justice. That's what Mitchell is saying. There's no special procedure that needs to bring it forth. If I'm there, I should be able to seek the administration of justice, and that court should fit in my claim. Now, in Vincent versus Ottawa, look what it says here. It talks about the Courts of Justice Act, and it reads as follows. This is a court judgment. The Superior Court of Justice has all jurisdiction, power, and authority historically exercised by the courts of common law and equity. So our superior courts in our provinces have all the power and authority that were historically exercised by courts of common law and equity. The only difference now is that this authority and power, it flows through the Charter. Now again, in Article 26 of this same judgment, he writes that it stands for the proposition that the Superior Court is a court of general jurisdiction and has all the powers that are necessary to do justice between the parties, except where provided specifically to the contrary. The court's jurisdiction is unlimited and unrestricted in civil matters. So here it says the Superior Court has all the power necessary to do justice, unless what? Except where provided specifically to the contrary, except if it was the Federal Attorney General of Canada that was charged with the administration of justice. Then the Superior Court wouldn't have the power to deal with it, because another court has the power to deal with it. But if it's a provincial matter, if it's the Attorney General of the province, then the Superior Court has all the power to deal with it, and has all the authority to deal with this common law matter, with this fundamental right and freedom. Now remember, the Supreme Court of Canada again, in M versus Ryan, says that common law must develop in accordance with the Charter, and that a trespass in common law equals an infringement or denial of a fundamental right and freedom. Now, Vincent versus Ottawa, it states that the Charter therefore does not bestow upon the court jurisdiction it previously lacked. It does, however, grant persons, and notice the S there, rights not previously enshrined, which may be enforced by courts of competent jurisdiction having powers acquired independent of the Charter. Now, when you look at the word person in general, if you just go to a dictionary and you look at the word person, it's going to break down in two ways. You're going to find that it's going to say it can either mean an artificial person, or it can mean a human being, or man, or a woman. So when it uses the word persons here, that's why they added the S to include both capacities, because we know the Charter opens up both ways. The Superior Court has all jurisdiction, power, and authority that's been exercised by common law courts prior to the Charter. The Superior Court has inherent jurisdiction. However, common law now is expressed through the Charter. Now we're looking at another judgment, Scarola versus MNR, 2002. The term inherent jurisdiction is one that is commonly, not always accurately used when arguments are made with respect to the jurisdiction base upon which a court is asked to make a particular order. The inherent jurisdiction of a superior court is derived not from any statute or rule of law, but from the very nature of the court as a superior court. So we are seeing that the power to administrate justice in a superior court is not flowing from or coming from any statute or regulation. This power to administrate justice comes from the very heart of the court. When an individual is seeking the administration of justice, they are not accessing a court that is a statutory court, but a court of inherent jurisdiction. Now just the opposite, in Scarola versus MNR, it says the court, as a statutory creation, does not have the inherent jurisdiction. So, a superior court, when it's a statutory creation, when it's being regulated and controlled under enactments and regulations, it does not possess, it cannot exercise its inherent jurisdiction. However, when you are dealing with this court, seeking the administration of justice, it then does have the inherent jurisdiction. It can regulate concerning fundamental rights and freedoms. It has all power and authority to deal with common law breaches, with breaches of our fundamental rights and freedoms. The Superior Court, as a court of inherent jurisdiction, has the power to administrate justice, our common law rights, our charter rights. The Superior Court, as a statutory creation, has no inherent jurisdiction. What we are seeing is a two-faced court, or a two-sided court. The Superior Court, on one hand, has all jurisdiction and power. It has inherent power to deal with the administration of justice. Then, it is also a court of statutory creation and does not have the inherent jurisdiction. Now again, in R.E. Mitchell Estate and the City of Toronto, this is a judgment. It says, it appears clear that the Supreme Court has broad universal jurisdiction over all matters of substantive law. And again, and the rule for jurisdiction is that nothing shall be intended to be out of the jurisdiction of the Superior Court, but that which specifically appears to be. So if an individual was seeking the administration of justice and went to the Superior Court of their province, it has the inherent power to grant the remedy, to grant what you are seeking. However, if the right you are seeking was under federal control, then the Superior Court would have no power to hear your claim. Now, Viscount Haldane, for the Privy Council, in dealing with the question of the nature of the jurisdiction of a superior court, said, if the right exists, the presumption is that there is a court which can enforce it. If no other mode of enforcing is prescribed, that alone is sufficient to give jurisdiction to the Queen's Court of Justice. Here it says King's, because this was from 1667, but nevertheless now it's the Queen's Bench, Queen's Court of Justice. In order to oust jurisdiction, it is necessary, in absence of a special law, excluding it altogether, to plead that jurisdiction exists in some other court. This is the effect of authorities. So the only way the Provincial Attorney General and the Superior Court of the province could refuse to hear your case concerning the administration of justice is that if it was under the control of the Federal Attorney General of Canada. If the right exists, then the presumption is that the Superior Court can enforce the right as long as the protection of the right is not assigned to another court. Since the Superior Court has inherent jurisdiction, it has the ability to enforce a right, administration of justice, if the enforcement of this right was not assigned to another court body. Superior Court must enforce the right. Common law right flows through the Charter. If the right exists, it's sufficient to give jurisdiction to the Superior Court. Again, in AG, Attorney General of Canada versus the Law Society of British Columbia, in his judgment, he states that these courts, provincially organized superior courts, are surely bound to execute all laws in force in the Dominion. Okay? All the laws, whether they are enacted by the Parliament of the Dominion or by local legislators. Now he goes on, and they are bound to take cognizance of and execute all laws, whether enacted by the Dominion Parliament or the local legislators. So we saw some of the attributes of the Superior Court is that it possesses all jurisdiction power that was exercised by the common law courts. And when you look at these judgments, this is talking about going back to 1667, even farther. The Superior Court has the inherent power, but this power does not come from statutes or regulations. Remember we talked about a statutory court, where it gets its power, its guidance from enactments? Well, the Supreme Court of Canada, its power doesn't come, its inherent power does not come from enactments or regulations. It comes from the fact that it exists. And the Superior Court, has universal jurisdiction over all subject matters. And it goes on to say that if the right exists, then the Superior Court of your province, it can enforce it. You see, this court here, the Superior Court of your province, is bound to enforce all laws, whether executed before the Dominion of Canada or after the Dominion. That's what the Supreme Court of Canada says. Again, the executive powers, they create enactments and regulations. And if these enactments and regulations strip you of your fundamental rights and freedoms, if you catch them taking away your fundamental rights and freedoms, the judiciary, the Supreme Court, the Superior Court, is supposed to be here to help you in order to seek the administration of justice and say, executive powers, those laws that you are creating are going against the Charter. And more specifically, they've gone against that individual's fundamental rights and freedoms. Now, therefore, there are no force or effect against that individual. We saw R versus Haynes, where it said prior to the Charter, we didn't have much power to protect ourselves. But now, since the advent of the Charter, we have the ability to challenge the executive powers and say, that enactment that you're trying to force against me, it's stripping me of my fundamental rights and freedoms. Therefore, I'm going to seek the administration of justice, and I'll find it in the Superior Court of my province. If it's a provincial matter, and if it's a federal matter, I'll find it in the Federal Court of Canada. The Queen's Court, which we know as the Superior Court, is bound to take recognition of all laws that are enforceable on this territory. The courts are bound to enforce the right. Common law, trespass, equals a trespass of our Charter rights and freedoms. Common law develops with the Charter. Charter grants rights not previously enshrined, that were not guaranteed before. They existed, but they weren't guaranteed. Now, in Vincent versus Ottawa, again, it says the Superior Court of Justice has all the jurisdiction, power, and authority historically exercised by courts of common law and equity. Common law rights are enshrined or expressed and protected in the Charter of Rights and Freedoms. Prior to the Constitution Act of 1982, our individual common law, natural fundamental rights and freedoms were not enshrined, and these rights, whatever they were very difficult to uphold and enforce. Now, Eldridge versus British Columbia, Attorney General, 1997, there is no question, of course, that the Charter applies to provincial legislation, the ones who make the enactments and regulations provincially. There are two ways, however, in which it can do so. First, legislation may be found to be unconstitutional on its face because it violates Charter right and is not saved by Section 1. In such cases, the legislation will be invalid and the court compelled to declare it of no force or effect pursuant to Section 52, Section 1 of the Constitution Act of 1982. Secondly, the Charter may be infringed not by the legislation itself, but by the actions, you see that, by the actions of a delegated decision maker in applying it. In such cases, the legislation remains valid, but a remedy for the unconstitutional action may be sought pursuant to Section 24, subsection 1 of the Charter. Action taken under statutory authority is valid only if it is within the scope of that authority, since neither Parliament nor the legislator can itself pass a law in breach of the Charter. Neither body can authorize actions which would be in breach of the Charter. Thus, the limitations on statutory authority which are imposed by the Charter will flow down the chain of statutory authority and apply to regulations, bylaws, orders, decisions, and all other action, whether legislative, administrative, or judicial, which depends for its validity on statutory authority.